You have the permanent bar in immigration and you're wondering if you can still somehow receive your papers. I want to talk about that in today's video. My name is Ashley. I'm an immigration attorney. I've been practicing for nearly 13 years. I have two office locations. One is in Carlsbad, California, and the other is in Bend, Oregon. However, because I practice immigration law, which is federal, my office is able to help clients who are located all over the United States. In this video, I want to explain what the permanent bar is in immigration law and certain case types where it's still possible to receive lawful status even if you have the permanent bar. The permanent bar refers to two situations in immigration law. And unfortunately, many undocumented people have what is known as the permanent bar. How is the permanent bar triggered? The first way is if you are undocumented and you have entered the United States unlawfully after April 1st of 1997. You've been here unlawfully for more than 1 year, and then you have left the United States and you have returned again unlawfully. In that scenario, you have what is called the permanent bar. Another situation where the permanent bar comes up is if, again, you have entered the United States after April 1st of 1997, you've entered unlawfully, you have been living in the United States for a year or more unlawfully, you then depart the United States and you try to come back in unlawfully and you are caught by immigration. If that happens, you also have the permanent bar. The other scenario where the permanent bar comes up is if you receive a deportation order. So let's say you are trying to enter the United States with a fake document and you are caught and you are given a 5-year deportation, which is known as an expedited removal. This typically happens at a port of entry when somebody is caught by immigration trying to use a fake document. They most often are given an expedited removal, which is a 5-year deportation. They are then returned to their home country and they are told they cannot return to the United States for a period of 5 years. However, that person instead returns very shortly thereafter unlawfully, or at some point before that 5-year period is up, they have returned unlawfully, or even after that 5-year period is up, they have returned unlawfully. That is a situation also where you would have the permanent bar. So these are the main scenarios where somebody receives the permanent bar. This means that they are barred from applying or receiving a green card um, until they spend 10 years outside of the United States. So this means that if you have the permanent bar and you are married to a US citizen, you do not qualify to file for your green card based on that marriage until you have spent 10 years in your home country. Now, there are certain case types where there is a waiver available if you have the permanent bar. These case types are a U visa if you are applying for a visa as a victim of a certain crime and you have helped in the investigation. There's a waiver available if you are applying as a victim of different types of human trafficking. That can also be labor trafficking. That's known as the T visa. There's a waiver available for the permanent bar. And there is a waiver available if you are petitioning under VAWA as the abused spouse of a US citizen or lawful permanent resident, or as the abused parent of a US citizen child who is over the age of 21. In certain situations, you can qualify to ask for a waiver if you have the permanent bar, if you can show that there is a connection between when you triggered that permanent bar and the abuse that you have experienced. So those are the three case types where it's most common to receive a waiver for the permanent bar. But again, there is no waiver for it if you are trying to file for your green card based on your marriage to a US citizen. You have to wait the 10 years in your home country before you can apply for your green card. And even at that point, you need to file additional paperwork with your green card application, specifically because you had the permanent bar. So if you have any of these scenarios where you have triggered the permanent bar, or perhaps you are not entirely sure if you have the permanent bar, you just know that you have a lot of entries and exits and you aren't sure, if you ever received a deportation at the port of entry. Sometimes clients are apprehended at a port of entry, but they aren't necessarily deported at that time. They're given what's called a voluntary departure. These are all very nuanced situations that require an immigration attorney to analyze and to tell you whether you have the permanent bar or not. So my recommendation is, if you have any kind of history with immigration, that you definitely consult with an immigration attorney before just filing applications for immigration benefits, to make sure that you qualify for it. And also, if you're going to require a waiver, and is the case type that you're filing, is there a waiver available for that case type? So don't forget to like and subscribe to my channel. And if you have any further questions, don't hesitate to contact us at 760-812-3778.